Honorable Justice R. Subramanian, respected seniors, dear members of the bar. Today, Mr. P.B.Balaji, he is from P.B.Balaji's office. The authority, he is the authority on Rent Control Act. So we have invited him to speak on this subject, new tenancy laws. He will enlighten us, followed by interaction. Then he will supply the whatever materials to our members. He will circulate it later. Thank you.
Good afternoon to one and all. Honorable Justice Subramanian, senior lawyers, dear friends. I'd like to be as brief and light as possible. I know most of you, like me, have not had your lunch. You may have to go back to court by 2:15. I always like to be brief for three reasons. One, I am a lawyer. Unlike exceptionist, probably RSMJ, all of us need briefs. He doesn't need one. Anymore. And I have known the incident of a long and winding speaker who, once he gets a chance, he doesn't leave the mic. His wife was sitting in the audience. We sent a note. The person sitting next to the speaker happened to see the note. It said kiss. So he was overwhelmed, said, wonderful, very nice gesture on your part of your wife to give you a warm greeting before you start. That this kiss is different. Keep it short, stupid. So I don't want kisses from those kisses from the audience. So I'd like to be as brief as possible. Coming to the
maybe another reason you are not paid for this.
Coming to the new Rent Control Act, a lot of my friends were asking me, the Act has not come into force. Why this subject? Recent developments are causing a lot of confusion. So I thought it is the right time to speak about the Act. It is like 2017. 2017 is not yet over. 2018 is yet to begin. But we know for sure 2017 is going to come to an end. 2018 is beginning. That is the status of the old Rent Control Act, NADU Buildings Lease and Rent Control Act, because the new Act has become a legislation, Act 42 of 2017. It has received the assent of the Governor on the 4th of August 2017 and also published in the Gazette on the 7th of August 2017. But there is section 1(3) which says the Act will come into force only on the date it is notified to come into force. That is yet to happen. But this section has escaped the attention of many of our friends, and they feel the Act has already come into force because the Governor has given assent on the 4th of August. It is not so. So we can continue to file proceedings under the old Act, namely the Tamil Nadu Buildings Lease and Rent Control Act 1960 as amended by 1973, and we have to wait for the date of commencement of the new Act, which is probably we can await any time. I was telling one of my friends, the old Act has gone into coma. It's on ventilator, so we don't know when it will pass out. Before I slightly take you to the new Act, a brief peek into the history of the rent control legislation. This landlord-tenant disputes is a burning issue not only in India, but in many countries like Britain and European countries. So there was need felt that there must be a special enactment to deliberate disputes between landlords and tenants. In fact, before the World War, I was told there was a lot of buildings not occupied. Later when one villager from Andhra Pradesh came to Madras, he saw many boards to let and vacant. He went back to his village. Somebody asked him, how do you find Madras? I found two very rich people. One was to let Durai and one was vacant Durai. So those were days before the World War. But the World War created an emergency situation. Landlords started exploiting tenants, they were rack renting, and tenants were fleeced by landlords. So that was a time when the British period thought we should bring certain curbs, and they brought the Madras house rent control orders for residential buildings and the Madras go-down rent control orders for non-residential buildings. This was replaced by the Madras buildings Lease and Rent Control Act in 1946. That continued up to 1960 when the present enactment came into force. The purposes of the Tamil Nadu Buildings Lease and Rent Control Act was to regulate the letting of properties, regulate control of rent, was the object of the old act. But now there is a marked shift in the objects of the new act. If you see the objects of the new act, it says to balance the rights and responsibilities of landlords and tenants. The statements of objects and reasons for the act. The purpose of the Tamil Nadu Buildings Lease and Rent Control Act, that is the old act, was to regulate and control the rent as well as the powers to government to take over certain properties against the wishes of the owners. These provisions made long back when supply of rental accommodation was limited. Real estate business had not developed and properties were vested in the hands of few people. But now the government thought real estate has picked up, there is a lot of accommodation available, cities have expanded into the villages and suburbs, therefore no longer tenants should be seen as the weaker sections of the society. We will remove the control of the law, we will give importance to the contract between the landlord and tenant. That is the letter and spirit of the new act. In fact, if you say the old act, I would jokingly say when I had spoken about the old act, landlords are fools for tenants, to build houses for tenants to enjoy. That was the essence of the old act, because we have known from 1960 litigation, though it is supposed to be a summary act, it took years, 30, 40 years, and the Supreme Court had to make a smart departure and said 40 years litigation, we have to put an end to it. It was a landlord-tenant dispute. And they were taking advantage of the lacuna in the provisions and change in the societal trends in the society also were affecting the old act. The high time a new act came into force. So in 2011, the central government suggested a model tenancy code, because it is a state act. Rent and land is a state act. Therefore, they could only suggest, and our government was the first to catch on and said we will adopt, and they have verbatim adopted the model tenancy code of 2011, and the present Act 42 of 2017 has come into play. What is the difference between the old act and the new act? There is a lot of misconception that powers of courts have been snatched away, given to deputy collectors. It is not so. It is, I would probably draw a parallel to the Consumer Commission. The new act is somewhat styled like the Consumer Commission. There is a rent authority who is somewhat like a registrar with limited powers. Then there is a rent court. Then there is a rent tribunal. The rent court will be headed by a district judge, not less than a rank of a district judge. Therefore, from powers of the district municipal present rent controllers, the powers are being transferred to the district court, which is a good organ in my opinion. And from the rent court, the proceedings will, by way of appeal, will go to the rent tribunal. The principal appellate tribunal member has to be a judge of the High Court. Therefore, and it has become, from the rent tribunal's order will become final. Of course, the act doesn't say what is the further remedy. Of course, whether 227 will apply is again bone of contention and going to be debatable. So, what are the new provisions which we will see? I will, because of paucity of time, I will highlight the significant factors alone. Fair rent has been done away totally. There is no provision under the new act under which either a landlord or a tenant, unlike section 4 of the old act, can approach the rent controller or the rent court here and say, please fix fair rent for the building. What the tenant is paying is very low, or what the landlord is demanding is very high. So section 4 has been totally wiped out, because the object of the act is allow the market forces to control. If the landlord and tenant agree on a particular rent, on a particular period of lease, please allow them to do it. So importance is given to the contract rather than the statute. Then there is a mandatory condition for registering the agreement between the landlord and tenant under section 4. You have to register your agreement with the rent authority, and the rent authority will upload the details in the internet, so it's a public document, anybody can see. And if there is a failure on the part of the landlord and tenant to agree upon terms, this pertains to existing tenancies. There is a period of 12 months from the date of commencement of the act, within which existing landlords and tenants also will have to report the earlier agreement or draw up a fresh agreement and report it to the rent controller. Beyond that, if there is no agreement, landlord has got a power to determine the tenancy and seek for eviction, which is going to be a very draconian provision. It's total complete shift in balance in favor of the landlord. A tilt in balance in favor of the landlord. This particular provision where there is no agreement to reach a rent, the power of eviction is vested with the landlord, in my opinion, is going to be a very serious provision which is going to affect social justice. Tenants may be at the mercy of the landlords. We will have to see how the constitutional validity, if it is tested, how the courts will go. There are new Section 2, the definition clause, property managers have been now recognized under the new act. So we know there are absentee landlords, many landlords own properties here, they are abroad. So they identify persons as property managers who may be a manager for 10 flats in a building. So the act recognizes that particular kind of agency, property managers. It defines property managers. It also recognizes special category of landlords like widows, armed forces and senior citizens. For them, it is a somewhat fast track is made available for them. And what is important is the limitation. This act is supposed to give a very speedy justice, and the intention of the act is definitely carried out in the various sections, because for all provisions, for all orders passed by the rent authority, a 30-day period appeal to the rent court. From the rent court, 30-day period to the rent tribunal. But what is important is the rent control court has to decide the application within 90 days. Outer limit is 90 days. And in case of owner's occupation and misuse of the property or nuisance, it is only 30 days. So there is a cap of 30 days within which the proceeding should be completed. And similarly for the rent appellate tribunal, which is going to be the revisional court, a 120-day limit is fixed, outer limit of 120 days from the date of service of notice on the opposite party. So the object is very laudable, and execution, most importantly, within 30 days from the date of service of the notice. And it is going to be decided summarily. Therefore, I'm confident Section 47 and 21 are given a go by, because the Act itself says CPC is not made applicable unless to the extent where this Act is for probably summons of service, reviewing the order, recalling the order. Certain specific provisions have been made applicable from CPC, but otherwise CPC is not applicable. But there is one clause which says the court which in execution is a civil court. So therefore, as lawyers, we may try to bring in the R21 in Section 47, which we will have to see, because the object is to complete the matter within 30 days. And that will happen or not is one aspect. Then coming to rent, as I said, there is no fair rent. The revision of rent will be as per the agreement.
That's unfair.
Revision of rent will be as per the agreement. So it is for the tenants to be very smart, have a watertight agreement for as long as period they want. Because suppose, for example, somebody studying in a nearby school, after a period of 2 years, the landlord wants a phenomenal increase in rent. The tenant may not be in a position to shift his family immediately and walk out. But the landlord has got a power. In case the tenant does not agree, he goes under Section 21(2)(a) and says, please vacate, because you have not agreed to the rent. So this clause, I feel, is a little draconian, which needs to be softened down. At least probably the courts will come down on it. And as usual, the other clauses, the owner's occupation, then default in payment of rents, nuisance, repairs, demolition, reconstruction, everything is retained. But one remarkable feature is there is no more willful or bona fide. Default is sufficient. If there is a continuous period of 2 months default, you are entitled to move the rent court for eviction. Eviction is always to the rent control, rent court, not to the rent authority. The rent authority's power is limited to receive and register the rental agreement, decide disputes. If there is a dispute, what is the rent payable, what is the revision which is due, when it is due, all those limited issues are before the rent authority. Similarly, there is the essential service which is cut off. Stamp duty is silent. Because rules, I must also mention here that rules are not in place. The courts or authorities have not been designated. So we will have to see what is the effect of stamp duty registration on whether it will be double stamped. Because already if it is an agreement of 12 years and more, we will have to register it under the Stamp Act, under the Registration Act. More than 12 months. More than 12 months. I think, but my Lordship had taught me a lesson. Even if it is less than 12 months, under the Transfer of Property Act, it needs to be registered. Section 108 and 111, I think. 107.
Popular misconception.
Popular misconception. And there is also an advance in security deposit. Under the old Act, Section 7 encompasses everything as a security deposit or a premium advance, whatever you call it, it will come under Section 7. You are not entitled to collect more than 1 month's rent. But here, there is a distinction between advance and security deposit. Security deposit can be collected up to maximum of 3 months. And it is repayable not across the tenant vacating, but within 1 month after the tenant vacates. So So landlord can enter the property, see whether there is any damages to the property, set off the security deposit of 3 months available with him, then refund. But advance is repayable across the tenant vacated or before the tenant vacates. And there is no cap in the new act to what is the amount the advance can be collected. It can be 10 months, it can be 11 months. Because as the object of the act is to allow the landlord and tenant to be free to fix the terms. That is respected. Throughout the act, if you see, the contract between the landlord and tenant is respected. That is the essence of the new act. Then what else is new is the landlord can enter the property and construct an additional floor, which was not available in the new. Once the property is given to the tenant, you have to wait till the eviction proceedings are over, tenant is vacated to even construct an additional room. But here the landlord can approach the rent court and seek permission to put up additional structures. Similarly, if there is an open space, you can approach the rent court and say, please permit me subject to municipal laws. Suppose there are 20 ground property, there is only one ground, the house is occupying only one ground. The landlord can say, I need to develop the property which is lying vacant, you please permit me, tenant cannot object. The rent court has got the power to permit the landlord to put up, to make use or exploit the appurtenant vacant land. This is an additional factor. And with regard to legal heirs, the successors are mentioned in the new act. Unlike the old act, tenant was, the person who was associated with the business of a tenant, he need not be a blood relative of the tenant. He was also recognized as a tenant under section 2(8). But whereas under the new act, the successors are very clear. It is named, it is either the spouse, sons or unmarried daughters, parents, daughter-in-law being the widow of a predeceased son, and provided the successor was ordinarily living or working in the premises with the deceased tenant up to his death. Therefore, it rules out the third-party interest insofar as the death of the tenant is concerned. And subletting, there is of course a restriction. Then section 10 seems to suggest something like fair rent, but in my opinion, section 10 has to be read with section 9. Section 10 says rent authority to fix or revise rent. It suggests that there is a power on the rent authority to fix fair rent. It is not so, because the rent authority on an application made by the landlord or the tenant shall fix or revise, as the case may be, the rent and other charges payable by the tenant, and also fix the date from which the revised rent becomes payable. This has to be read in line with section 9, which is revision of rent. What circumstances the rent can be revised is set out in section 9. So if there is a dispute in section 9 alone, section 10, rent authority's power will come into play. This is my respectful submission. Then deposit of the rent authority, section 8(5) has been modified remarkably. So there is no more money order. You just make an attempt to pay him in 2 months. If there is a refusal or unable to tender the rents, you approach the rent authority and deposit the rents. And there is a bona fide dispute, the rent authority will decide who is the person entitled. You can withdraw the deposited rents also. And there is also a penalty in case you don't vacate in spite of the eviction order, or in spite of the notice period given by the landlord, or in spite of the agreement coming to a lease. Section 23, it says double the monthly rent as penalty. So that is going to be definitely a threat. A sword is hanging on the tenant's neck. If you are going to delay the proceedings, you run the risk of paying double the rent for every month. So as long as you delay, if your rent is 20,000, the court can say pay 40,000 if you are going to delay proceedings for the landlord. The refund of advance, as I said, has to be done across the tenant vacating. Then of course, like 11(4), payment of rents is contemplated pending proceedings. Tenant has to pay. Now, you can, as lawyers, you can advise landlords to include interest for defaulted payment. In the earlier act, there was no provision for payment of interest on defaulted rent. Here, the act recognizes interest for delayed payment. It is not, you cannot say there is no willful default or default because you are charging interest. You are allowing the tenant to pay accumulated rents because you are charging interest, but this is no more available in the new act. You are entitled to charge interest for delayed payment of rents. In appeals, as I said, from the rent authority, appeals will go to the rent court. From the rent court, appeals will go to the tribunal. And what happens to the pending proceedings? There is repeals and savings clause, section 40, section 47, repeals and savings. As far as pending proceedings are concerned, the act is continuing to be in force, and the eviction proceedings, the fair rent proceedings filed before the date of commencement of the act shall continue as if the new act had not been brought into force. That has been clearly set out. There is also an exit option given to landlords alone. Landlords alone can choose whether pending the eviction petition or pending the appeal, they can withdraw within a period of 180 days from the date of commencement of the act. They can withdraw their petition or the appeal, provided the landlord, it's now tenant is not given the option, it is the landlord who is given the option. He can withdraw the eviction petition or the appeal, and within 270 days from the date of the commencement of the act, he must come under the new act. And like composite leases are still continuing to be exempt, government properties are continuing to be exempt, trust properties are exempt, but an option is given for such exempted landlords to voluntarily come under the act and register the agreement with the rent authority. That is set out in section 5 itself. Tenant is not willing to come for registration. That this will happen only for existing tenancies. The landlord can give a separate form filled up as per the schedule and say this is my particulars, tenant has to give. If there is no agreement within 12 months, landlord can seek for eviction under 21. Now the important point to it, like section 10, section 21 is dealing with eviction, repossession. The most important clause which I was referring to was 21(2)(a). The landlord and tenant have failed to agree to a rent payable under section 8. It is a ground for eviction. So this, I feel, may require reconsideration because landlords may exploit. Maybe there should be a cap saying if I say I demand 1 lakh rupees of rent, I must not let out the property for not less than 1 lakh. Then the landlord will also be wise enough not to fix an arbitrary rent. But tenant must also be reasonable. Therefore, the 21(2)(a) where landlord and tenant fail to reach an agreement is a ground for eviction. This applies to existing tenancies or after the lapse of the new tenancy. Any new tenancy has to go under the new act. There is no exemption because and whatever is not set out in the agreement cannot be used as evidence in court. So all your terms have to be incorporated in the rental agreement. Therefore, we will have to be very cautious in drafting rental agreements hereafter. And the default, there is an interesting provision. If there is a default and I come to court complaining of willful default, tenant has an option to pay the arrears. He is exonerated once during an academic year. The petition will be dismissed. But he can't repeat the offence second time in the same academic year. So that is one leverage given to the tenant.
Same here.
More or less I have summed up the important aspects. You have any questions?
But did you cover the court fee aspect?
Court fee, yes, sorry. Court fee Act, the Tamil Nadu Suits and Valuation Act has been made applicable, and it no longer RCOPs, it is going to be treated as a suit. So the suit between the landlord and tenant, and landlord tenant is Act section 30 will apply.
Can one draft a clause in the tenancy agreement
Yes.
which essentially restricts the landlord's ability to build on that property during
Yes.
the course of the tenancy?
Definitely, yes.
So which will take precedence, the act or the?
No, the agreement is the agreement. In the absence of an agreement, the landlord can approach the rent court. But if the agreement prohibits him, definitely he is not entitled to do it. Because the act recognizes and respects the agreement between the parties.
Still the money order is there.
Money order or such other mode. Not earlier it was only money order. Now the money order or such other prescribed mode. Any building lease will come out of the act. After that test will still, that issue is still burning. Whether it's a lease or license will not the nomenclature, but what are the terms between the parties. Yes, if it is a license, that will not apply. It is only lease. Yes, yes.
You said registration.
Registration.
Registration means the normal registration before the SRO or registration
With the rent authority.
Rent
With the rent
authority.
authority. So whether it will also require additionally, if it is otherwise registrable, we will have to see whether this registration is sufficient or you will have to register
Now,
before the.
whether you have a rent agreement or not, once you receive 1 month's rent, he becomes a statutory tenant. Now, whether there is any change on that aspect?
Definitely, because no longer can be the oral tenancy.
There must be
There must be an agreement in writing and registered. Otherwise, you cannot.
registered with the rent
Rent
authority,
authority.
not with
If
the
it is for 11 months or 10 months, you can register with the rent authority, but it requires to be seen what are the rules. Once whether it also requires registration under the before the sub-registrar.
More than 12 months, we have to register for the stamp act.
Yes, as part we have to wait and see whether registration to rent authority is sufficient rules on.
What about the stamp act, applicability of the stamp act?
Stamp act.
What is the stamp duty payable?
Rules are silent. What is it? It is going to be nominal fee for the rent authority.
Does the Tamil Nadu stamp act as it exists apply, or is it going to be a special stamp?
We have to wait and see. That is silent.
Tenancies are lock and key. If a distress application, consecutive 2 months not paid, that is retained or distress application before.
It's a seizing document. Seizing document. Seizing document.
Earlier it is 6 months.
4 months. 4 months. Continuous period of 4 months.
The 10 months.
I don't see any eviction clause on that ground. Seizing document.
Balaji, no, he's asking for distress application. Comes under the small class.
Small class is protected, not under the rent control act. Distress application to recover the money. This is only recover possession. We are concerned more with possession, not with the money aspect under the rent control act. Incidentally, 11/4 will get you the money if you are lucky. It will not get you possession, it will get you money. The arrears. And there is one more protection to the landlord. Tenant can opt to give a notice to quit and say I am vacating by the end of next year. And believing that representation, landlord agrees to sell the property and tenant does not vacate. That gives a ground for the landlord to evict. There's going to be no boiling down to negotiation between landlord and tenant.
What is section 9 you said?
Section 9 is fixation of rent, revision of rent.
Revision of rent, how does it?
Revision of rent, it says, as per the terms of the tenancy agreement. Save as agreed in the agreement, landlord shall give a notice in writing 3 months before the revised rent becomes due. For tenant who has been given notice of intended increase of rent, fails to give landlord notice of termination, either he accepts or vacates. He either issues the landlord a notice of termination, tenant shall be deemed to have accepted whatever rent increase has been proposed by the landlord.
What about 10? Where does 10 come into play?
10 says, the rent authority on an application made by the landlord or tenant shall fix or revise as the case may be the rent and other charges payable by the tenant and fix the date from which the rent.
No, as a landlord I make a demand.
Yes.
But the tenant doesn't agree. Then what happens?
Tenant doesn't agree, or it gives you a ground for eviction. By 21 year.
What is the role of 10 then?
10, my reading of that is, suppose there is an agreement. Tenant says this is how you interpret that clause, renewal clause. I'll pay only so much. Now landlord said no, this is not how you interpret, you must give me more. Those disputes will be decided under section 10 is my respectful reading of the section 9 and 10.
What if the agreement doesn't speak of the revision clause? What if the agreement doesn't?
You have to decide within 6 months the old agreement will continue for the same terms. Before that you either enter into new agreement or get out. So I think there is a clear shift in balance favor of the landlord.
Rent is the consent of the landlord.
Rent?
Deducted without the consent of the landlord.
Deducted from?
Deducted from the normal rent without the consent of the landlord.
No, sir. Rent or portion of rent, charges not payable. Everything you can file for default.
So for deduction, how is the interest rate fixed?
As per the agreement, court will not comment. If your agreement provides an interest for delay, yes, any percentage, any rent, any percentage, any advance.
Says application by landlord or tenant.
Yes.
So they can
Interpretation of the agreement.
Interpretation, because it doesn't say, unlike section 4, it sets out a formula and says this is how the fair rent should be fixed, market value of land. It doesn't speak anything about it. It is immediately succeeding section 9, so I thought this is relating to section 9.
There is one peculiar problem. Municipal Corporation Act says if the landlord doesn't pay the property tax, the tax can be paid to the tenant and adjusted against the rent. Will that continue?
Yeah, that is there. That is protected. Tenant fails in his duties, tenant can pay and seek to adjust. That is provided as similar to the old act.
The revision of rent is preserved under section 10 because it also gives an option for the tenant to file a petition.
That's why I said suppose there is a dispute, interpretation of the agreement. I don't see it as valid.
It only says rent authority on an application made by the landlord or tenant shall fix or revise as the case may be the rent or other charges payable. So, if in case the tenant is not satisfied with what is being fixed by the landlord, he is entitled to approach the authority to fix
The view which possibly can be there. But it goes against the letter of this act itself.
But then what will be the yardstick for the court to fix the
The yardstick must be the court We must look at the rules.
Look at the rules. Maybe is there to be one.
Wait for the rules.
We have been doing wonder with the tenants so far. Now it seems the Landlords Act. Now the abstract class what is new act.
Execution is summary proceeding 30 days முடிக்கணும் 30 days அது நடமாடுறது பாவம் we will allow it to happen is one thing we have to
police protection
see police protection at the cost of the landlord that is made available adjustment of
No, can that be adjusted towards the security deposit?
security deposit only after vacating
Cost incurred in eviction.
that's the march of law after you watch it can be
That is all for the judgment law.
In occupation, the owner can actually say that his accommodation is at present living is not sufficient. Earlier, that's a
he must be residing outside. Not in a building. This is a 21. That is retained. 21G. Premises let out for residential, non-residential purposes are required by the landlord for occupation of non-residential or residential purposes, or member of family, or for person whose benefit the premises is held. Landlord of such possession is not in possession of suitable accommodation. Suitable accommodation it improves the situation. And bona fide also.
Yeah.
It can be verified also.
Previously it was any accommodation, now suitable.
Suitable accommodation.
47 is now going to be reflected again.
Landlord bona fide. Thank you.
Balaji for enlightening us about the new landlord. We thank Mr. Justice Subramanian for participating in this program.
So let's all give
We
it to Balaji.
thank Mr. Hon'ble Justice R. Subramanian for consenting to give a lecture on Intersection Act during the month of January. Once again, we thank Honorable Justice R. Subramanian for consenting to give a lecture on Intersection Act during the month of January. Thank you.
Thank you.